great to see such a big crowd. A few Northwest Hills Council of Government updates. Most of you have grabbed a flyer when you came in. We have another legal training. Bruce Hyde will be giving Wednesday, March 18th for anyone that couldn't make it this evening or for anyone that wants to learn a lot more after this evening. That'll be at 7 p.m. at the Northwest Hills Council of Government's office. And there are other events coming up, the forums, our fifth Thursday forums. We do have topics such as housing and such as economic development. Those will be upcoming. So we've placed the calendar, put holds on dates for the upcoming calendar, and we'll be developing those topics further and sending out registrations for those events. So stay tuned. If you aren't registered to receive our emails, just let either Jocelyn or myself, I'm Janelle Mullen, the regional planner at Northwest Hills Council of Governments, just let us know you'd like to be included. And I'm very pleased this evening to introduce Attorney Zizka. He has advised or represented 60 different Connecticut municipalities as well as private landowners. His cases have involved issues such as affordable housing, subdivision development, wetlands activities, non-conforming uses, zone changes, environmental issues, and inverse condemnation or takings. He has drafted groundbreaking regulations. Many of you are very familiar with his book, What's Legally Required, and have asked about when the next update will be coming out. I met Attorney Zizka when I was earning my certification as a zoning enforcement official in the state of Connecticut, and to this day I still have notes in my office that I refer back to. So I hope this evening leaves you with some of Attorney Zizka notes to refer back to. Just to let everyone know, the format of the presentation is very informal. Attorney Zizka has encouraged me to inform you to feel free to ask questions and just give everyone a time to ask their burning questions and leave time for others to do the same. But thank you all for coming. So good to see such a great crowd. Thanks again. Without further ado, Attorney Zizka.
I can't believe how many of you came out to see this tonight. People get a life. There really isn't anything on TV, is there? No, again, these presentations, I like to try to be as practical as possible and to try to give you information that will be useful to you. And what I found in, how many years have I been doing this? It's been a long, long time. That many issues that come up that are surprising. I wouldn't have expected them to come up. I see questions coming up that I would be sure that I'm going to find an answer to in some court case, and it's not there because the question never came up in court, or it just never got up to the appellate court or the Supreme Court. And so sometimes we end up making law on issues that I thought would have been decided many years ago. And that's what I enjoy. I like being creative. I like trying to solve problems that nobody's ever had to solve before. And so there are a couple of caveats that I have to give you as I begin this presentation, and I do this every time. Although I welcome questions, and although I like to make the questions and answers or my discussions with you as informative as possible, I am obliged as a lawyer to worry about conflicts of interest. And obviously when you're asking me questions, I'm not going to be able to go into my computer and figure out if I have a conflict of interest with anybody that may be involved in the situation that you're describing. So what we have to do is we have to make the questions both as specific and as general as possible. In other words, they have to be hypothetical, okay? They might be close to a situation that you're encountering in your town, but they're hypothetical, right? They're hypothetical questions, and they don't involve any real people. Okay? So now that that's out of the way, I do encourage you, the whole point of what's legally required was to give you a grounding in the procedures of making the correct decision. How do you go about making a land use decision that conforms to the law, that's not going to get you in trouble, that's not going to make you or any member of your municipality have to pay money to somebody who feels that their rights were abused. That's the whole idea. This can be a mystifying area of the law. It doesn't have to be, though. There are some basics that go along with making a land use decision that we can understand. What I've given you tonight, the basic legal principles, this is what I'm going to focus on, and this is what I want to allow you to start getting into questions that you may have. Those of you that are familiar with what's legally required know that I had two things in the two appendices in the back. One was a step-by-step chart for how you go about making a decision. So step 1, step 2, step 3. And then there was also a chart that showed you for each particular type of decision that you might want to make, what kinds of things are you going to have to do at each point in time? What kind of notices are you going to have to give? When are you going to have to give them, and so forth? And what we found in land use law is procedural mistakes that you make are the ones that are going to get you if you're facing an appeal in court. It's not that you decided the wrong thing on a substantive basis. You didn't decide something wrong on the merits. You decided it wrong in following a certain procedure. There's something that you didn't do, or some legal thing that you ignored. And that's when the courts will say, okay, we're going to have to force you to do it all over again. We're going to overturn your decision and make you do it all over again. So the idea of what's legally required was to give you a format that was hopefully not terribly legally complicated when you're reading it, to allow you to go from step to step to step in processing an application and know how to do it, know how to get to the end point without making mistakes. So let me start with these. This material is going to appear ultimately in the new version of what's legally required. Let me tell you where that is now. This is the current version of what's legally required. Okay? What is happening right now is the Department of Energy and Environmental Protection has been reviewing this. I've been making some changes in to satisfy certain concerns that they have and address certain issues that they have. There are some other folks that are kindly reviewing the manuscript for me. It's still not clear how and when it will get published. What I can tell you is the text is done. The text is ready to go. But when I was first doing the edition, well, I've done several editions of it already, but there was a person at the Department of Environmental Protection, as it was called at that time, named Alan Williams, who was working with me and basically arranged all of the publications. So he got it formatted, he got it published, and so forth. DEP, now DEEP, is not doing that anymore. They don't have a bookstore anymore. They don't have a regular publishing facility anymore. And there's nobody in charge. There's no Alan Williams there anymore. So it's not been clear how this thing is going to happen. What I do know is DEEP doesn't publish things on its own. So we've been talking to people in my office, have been talking to the folks down at the Extension Service in Haddam that run a land use training program of their own. And that program and those personnel have indicated their willingness to help get the manual published. So we're now talking with DEP and CLEAR and the Extension Service and so forth about how this is going to get published and what the mechanics of that are going to be. So I do want to give you hope. It's going to be available, I'm hoping, within a few months, and the text is ready. It's just a matter of working out the mechanics of how it gets published and who exactly is going to handle that. But at any rate, you have got the first portion of the book that anybody ever has had so far. And what I tried to do here again, and this is going to be up front in the manual instead of an appendix, this is again sort of a basic flow chart, if you will, of how you go about making the decision. When you're making a land use decision, what are the things that you always need to keep in mind? And this will give you that guidance. So let's start with the basic legal principles for land use administration. As we're going through this, if I'm touching on anything that leads to a question that you may have, please feel free to raise your hand. Because again, My goal here is to make this as practical and useful to you as possible. All right, each municipal agency has a limited jurisdiction, meaning a limited scope of authority, and its authority is not inherent to the municipality. What that means is, although many of us in our municipalities don't realize it, our towns, our boroughs, don't have any inherent power. They don't. The only power that they have comes from state law. If the state had not provided law that said that the town of Cornwall can do this, the town of Litchfield can do that, the towns wouldn't have any power. Fortunately, the state has done that in the area of planning, zoning, and land use regulation. There are a lot of statutes that allow municipalities to regulate land use in their towns. However, the flip side of that is you have to do these things in accordance with state law because you don't have any power to change state law. So that's the first thing that you need to know. When you are exercising your powers as a municipality, you first have to look to state law to decide what you have the power to do. You have to make sure that whatever you are saying in your regulations is consistent with the way state law allows you to do it, and that the procedures that you're following are what state law requires. And most of the specific procedures that you have to follow are dictated by state law. Although municipal agencies require state authority to act, state law provides only a basic procedural framework for most decisions. An agency's decision-making methods and criteria will generally be spelled out in more detail by regulations that the agency itself has adopted. Okay, so what that means is, as I said before, the state has given you the basic procedures that you have to follow. And typically they're in terms of notice, they're in terms of time frames, how quickly do you have to act on something, who do you have to give notice to, that kind of thing, and all of that will depend on the kind of proposal that's being made by the commission or being made to the commission. So state law deals with that. But in terms of planning, state law says, okay, planning commissions, you can consider the following things when you develop your regulations. They don't dictate what you have to say. They don't dictate what your subdivision regulations have to provide. They say you can think about traffic flow, you can think about the capacity of utilities, you can think about all of these things, but the state doesn't tell you what kind of criteria to use to decide on a subdivision. In the zoning area, in particular, the state gives you no clue about what you have to consider, except lately, the state is saying you do have to consider affordable housing. And that's becoming more and more strict. The laws regarding affordable housing are becoming more and more strict. And that's sort of a world unto itself, and we can get into that a little bit later. But other than affordable housing that the state definitely wants you to make an effort to address in your regulations, they don't tell you about how much commercial you have to have, how much industrial you have to have, whether you have to have special permits. They leave that all entirely in your hands. Wetlands, it's the same thing. They tell you what wetlands are, they tell you what water courses are, and they tell you what you're supposed to consider when you're deciding upon a regulated activity, but they don't tell you specifically how to analyze all of these things. So what does that mean? It means that your regulations have to fill in all of these details, because the next important thing is, if you go to court, the court will, first of all, wonder whether you're satisfying state law. But then second of all, it's going to consider whether you're following your own regulations. Think about this a little bit. And again, I know many of you have long been on your commissions, and you know this stuff. I'm preaching to the choir for many of you, and I know that, and I apologize for that, but we have a diverse audience here, and I'm sure that some of you are newer to the game than others, so I want to make this as helpful to everyone as possible. When you go to court, the court's going to say, did you follow state procedures? Okay, step 2, did you follow your regulations? What courts don't like is when you're making a decision that's inconsistent with your regulations. And they also don't like it when you're making a decision that has nothing to do with your regulations. When you've regulated a particular activity by the seat of your pants. So, let's say, for instance, for a particular application, you have criteria A, B, C, and D. And then you decide the application and you deny it because of E. The court will say, no, E is not in your regulations. You didn't have any right to consider E. And it's not because the state prevented you from doing it, it's because your regulations didn't allow you to do it. If you think about this, when you file an application for something, and it doesn't have to be land use, you file an application, with the federal government for something in, Social Security or some kind of, government thing that you have to deal with. You want to know what the rules are. You want to know what you have to do in order to get the relief that you want from that government agency. And if you send in the information that the government requires and they come back and say, well, that's still not good enough, we want something else, you have a right to be upset about that. And the same is true with landowners. They want to know what they have the ability to do with their property. And so they want to know that when you're making a decision on an application that they've submitted, that you're complying with the regulations that you told them that landowner would have to follow in order to get an approval. You can understand why that is so important. You shouldn't be regulated by the seat of your pants. So you start with state law, procedures and criteria that are required by state law, and then the regulations. They fill in all of the gaps. If you're acting outside of those areas, you're probably making a mistake. I saw a hand. Yes?
Can you touch on the responsibility of the commission in interpreting their regulations?
Okay, the question is, touch upon the responsibility of the commission in interpreting their regulations. The courts generally reserve to themselves the right to make decisions ultimately on how regulations should be interpreted. Now that sounds strange to you, but the interpretation of regulations is considered to be a matter of law. And so the courts have developed a whole bunch of techniques and theories, if you will, procedures, criteria for figuring out how to interpret a regulation. And basically what they say, if the regulation is written in such a way that you can understand it, it literally makes sense. That's typically the way they're going to interpret it, even if you didn't mean it that way. If you said it that way, if you said you have to wear a blue jacket to get this permit, they're not going to allow you to say, well, what we meant was if you're wearing any kind of jacket. It doesn't have to be blue. The courts are going to say, no, you said blue. And that's what it's going to be. But if the regulation is ambiguous, then the court will say, okay, it's up to us, the court, to figure out in the first instance what that means. Now, if the commission or board has made a decision in the past about how to interpret that particular regulation, the court may give that some weight, but ultimately the court will say, but it's still up to the court. So the court will look at what the commission has said, but it considers the issue to be an issue of law for the court. If the commission, or whatever board or official is interpreting the regulation, has a history, a recorded history of interpreting it in a particular way, the more that's true, the more the courts will give that credit. The reason for that is, if you think about it, commissions change over time. The membership of commissions change over time. If you have a regulation that was passed in 1971, the likelihood is nobody on your commission today was there when that regulation was passed. So none of you interpreting an ambiguous regulation that was developed in 1971 are necessarily going to know what was in the minds of the people in 1971. And so because of that, the courts will say, well, our guess is as good as their guess. And so because we are the court and our job is to interpret ambiguous law, we will interpret it that way. And that's why if there's a history of interpreting something a certain way, and that has been consistent over time, the courts will tend to consider that to be a tried and true kind of interpretation. That is more likely to be reflective of what the commission has thought all along about that regulation. But that's typically how it works. That's typically how the courts will look at it. And what's interesting is that because it's an issue of law, when the trial judge makes a decision and it goes up to the appellate court doesn't have to pay any attention to what the trial judge says. Because the appellate court will say, no, it's an issue of law. So we have what they call plenary power, power of first impression, to make the decision ourselves regardless of what the trial judge said. Same thing when it goes up to the Supreme Court. They can ignore what the appellate court said and make their own decision. So it's not just you on the commission that are, that are having the court make a different interpretation. It's even the lower levels of court that are subject to that. Many state requirements involve the process leading to a decision rather than the substance of the decision itself. We've talked about that. The requirements may include furnishing notices of applications or orders, etc. They include directives on the times within which certain steps in the process must be taken. And when an agency fails to follow these procedures correctly, a court will often reverse or nullify its decision. So the timetables. If you're having a public hearing, if you're a planning, zoning, wetlands commission, some other commissions as well, you have to publish 2 notices of the public hearing. The first one has to be at least 10, but no more than 15 days before the hearing. And the last one has to be at least 2 days after the first one and at least 2 days before the hearing. Now, what you may not have known is the courts have interpreted that to exclude the date of the hearing and the date of the notice. So when they say there has to be at least 10 days, they're talking about 10 full days between the notice and the hearing. So if you publish a notice on the 1st, thinking, okay, the hearing's on the 11th, so I got my 10 days, nope, that's not the way the courts have interpreted it. Those kinds of things, though, often if you have good staff understands those kind of tricky timetable procedures. So I'm not going to spend a lot of time on those tonight. You don't need to know those tricky timetable procedures, but they're often easy to get tripped up on, and in fact, what the courts have said is if you miss those deadlines for a public hearing, your decision is void, and you're going to have your decision overturned in court. Notices that are given to particular individuals, if you have in your regulations something that says when you're filing an application for X, you have to give notice to neighbors within 100 feet or abutting neighbors or something like that. The courts consider those notices to be not as sacred, if you will. So if you fail to give one of those notices, then the only way that your decision can be challenged is if the person who should have gotten that notice is the one who's taking the appeal. If you actually did get a notice, you can't complain that somebody else didn't, even though it's in your regulations. And if you didn't get the notice, but you heard about it anyway, and you show up at the hearing, you've considered to waive your right to complain about it. So the notices that you give to your neighbors are not quite as critical, but in the right circumstance, somebody can challenge them. Many state laws for municipal land use regulation are designed to assure the public that decisions are being based on reasonably objective criteria and not on personalities, financial interests, or arbitrary seat-of-the-pants reasoning. In some instances, those rules may require an agency member to avoid participating or acting on a particular application or issue, in other words, to recuse himself or herself, even when that member sincerely believes that he or she can make an objective decision. The courts have held that it is more important for the public to have confidence in the process than it is for individual agency members to maintain their right to vote. Agency members should therefore be familiar with the circumstances that require recusal, including claims of bias for or against an applicant or opponent, prejudgment, which means effectively deciding an application before hearing the evidence, and personal or financial interest in the outcome of the proceeding. Of all the issues that can be raised against an agency's decision in court, these are the most likely to involve personal liability by individual members, and that is why I raise this issue particularly. Let me explain. This is something, and again, I've had many, many years of working with commissions. This is one of the things that agency members find it hardest to comprehend for some reason. It doesn't matter whether you really, truly, sincerely believe you can make an objective decision if it's your brother filing the application. It doesn't matter what you think you can do. What matters is what is the public likely to think. And if the courts see a situation where you have acted on an application where someone in the audience reasonably can question your objectivity, you are at risk. And you are at particular risk if your decision goes against the person that raises that issue. Because that is when those people can say, you have acted outside the scope of your authority, you have acted on grounds that are not based in your regulations, you have acted out of personal interest or financial interest, and by doing that, you have violated my civil rights. If a court finds that you have violated someone's civil rights by your action, number one, your municipality doesn't have to indemnify you for any damages that can be claimed against you. And you can be held liable for those claims. There haven't been many cases in Connecticut that have involved personal liability against commission members or staff, but there have been some. There have been some situations where commission members or staff have been found personally liable for when the evidence makes it appear very likely that that decision that you made or that decision that you influenced was made out of some kind of personal animosity or some kind of financial interest that you may have. So it's very important to understand the laws of recusal and when you need to step down from a commission. Yes, ma'am.
Is recusal voluntary, or can a commission ask someone to step down?
The question is recusal voluntary, or can a commission ask a member to step down? The answer is yes to both. A commission can ask someone to step down. Let me go to the third question you didn't ask. Can a commission force a member to step down? No. No, because the idea is that each commission member or a seated alternate has either been officially appointed to that duty or officially elected to that duty. So the idea is that that person has been put in that position of power by choice of the public, either acting through the election process directly or acting through an elected representative. And because of that, other members who have no more power than the one who's in the target, they have no power to force that person out of that position. So it's left up to the person who is being accused to decide whether she or he needs to step down. In those situations where a commission may feel very, very sure that an agency member is acting outside of the public interest by sitting on an application or sitting on a matter in which they have a personal or financial interest, but that member says, no, I'm not going to step down because I don't think I have any problem, the commission can take certain steps to say, you know, the chairman might say, look, the commission, most of the members of the commission feel that so-and-so had an interest that may call his or her position into question, and for that reason, we are not going to be taking that member's comments into consideration in making our decision. You can try saying something like that, because sometimes the courts will say, okay, this person shouldn't have voted, but if we can find from the record that that person's participation in the decision ultimately didn't have an impact on the outcome, then we can still uphold the decision. Most of the time the courts won't do that. Most of the time the courts will say, well, you know, this person shouldn't have been sitting on the commission for that application, but did, and because that person had, you know, made all sorts of comments and we can't know what impact that might have had on the rest of the commission members, we have no choice but to overturn the vote and send it back to the commission for a new vote without that person's participation. That's the most likely thing to happen. And again, the only possible way to avoid that is if other commission members who are voting say, I just want to make it clear for the record that I am not considering the comments from Commissioner so-and-so because I don't think Commissioner so-and-so should have participated in this vote. And that's certainly embarrassing for everybody. That's embarrassing for everybody. That's about the only way I can think of that you can protect yourself. Now, if Commissioner so-and-so sits on the application but doesn't actually do anything, and then just votes at the end, never makes a comment, what the court's likely to do is to decide whether the votes of the other members would have been sufficient in and of themselves to reach the same decision. And then the court might say, because that person refused to step down but didn't comment, it's clear that that person's didn't influence anyone else, that didn't say anything to influence anyone else, so we're just going to see whether that decision would have been made otherwise. But you can see how fraught that process is with danger. There was a question over here.
Can an applicant ask a board member to recuse himself?
Yes, the question is, can an applicant ask a board member to recuse himself or herself? Yes, an applicant can do that, an opponent can do that. An opponent can do that. There will be situations when that's true. But again, neither has the right to force them to step down. Now, a couple of things that you should know about that. If there's a situation where a person who is either an applicant or opponent, some stakeholder other than the commission members themselves, wants to complain that there's an issue, an ethical issue with the participation of a particular board or commission member, if it's something that that person knows about and doesn't raise it with the commission at that time, and then the decision goes against them, most judges will say it's too late. You knew about this issue, you didn't raise the issue at a time when that commission member might have recused himself or herself, and therefore, we're not going to allow you to bring that up right now. That's what most courts will do. I did see one case where a court didn't do that, but that was an unusual case, and I think, frankly, that judge didn't really understand that that was not the right way to rule on that particular issue. It was just one superior court judge. But most of the judges and the Supreme and Appellate courts have said, if you knew of an issue where you claim there was a conflict of interest and you didn't raise it, it's too late to raise it on appeal. There is an exception to that, though. It's not really an exception, it's a different circumstance. If you didn't know about the conflict until the time you brought the appeal, and you find out about it later, then you can raise it on an appeal. But you would have to prove to the court that you found out about the issue, or that there was no way you could have known about the issue until after the decision was made. That's the only way that the court will generally allow you to raise that issue on an untimely basis. Yes, sir. Yes.
When you have a commission member who has recused himself, is it inappropriate for them to still attend the meeting?
Good question. The question is, if there is a commission member who has been recused, is it inappropriate for that person to still attend the meeting? Judges. Am I talking too loud?
No, I can.
Oh, okay, all right, okay, that'll work. There are different ways of looking at that. I'm sorry. Now I just completely lost my train of thought. Ask me the question again.
When you have a commission member who has recused himself, is it
Okay,
inappropriate?
thank you. My God. I am getting old. I'm getting really old. There are different ways of looking at that. Some lawyers say, and I've seen some court decisions that say, the best thing for that member to do is step down from the table and walk out of the room. I don't go that far. I think that any commission member has a right to remain in the room. I do think it's not a good idea to remain at the table. The reason is because if you're recused, remember what I said before, what the court's going to wonder is, did you influence anybody else on that commission? And if you're sitting at the table, making faces or, rolling your eyes or something like that when people are talking, somebody might say you're influencing other commission members just by sitting there. There was one case that I remember reading, and I think it was a Supreme Court decision, where they talked about a commission member who said, okay, I'm going to recuse myself, but then during the course of the meeting was going like that, pointing to people and making all kinds of expressions while sitting at the table. And the court said that's too much. That's too much. We can't have that. That person was trying to influence the outcome of the decision. Therefore, decision overruled, commission has to do it all over again. So, my view is step down from the table, go sit in the audience, preferably sit in the back, so nobody can accuse you of sitting in the front and trying to, communicate indirectly with the other commission members, and do it that way. Obviously, it's safer if you leave the room. I don't think you have to do that, but definitely try to sit in a more inconspicuous location, and don't give anybody the opportunity to say that you were signaling to people on the commission. Yes, sir.
Oh, when this commissioner recuses himself, he doesn't automatically become part of the audience?
When a commission member is recused, from a legal standpoint, they become a part of the audience. But that's why if they continue to sit at the table, it's problematic. So they should go and sit in the audience. However, there have been some court decisions where they said if the person sits at the table and keeps his or her mouth shut, no harm, no foul. Sir?
What if they're in the audience now, they just recuse themselves, and you're giving input to the meeting?
Say the,
Person that recuse themselves, stay in the room.
yeah,
As proceedings are going on,
yeah.
they're giving input,
That's going to result in the decision being overturned. Yeah, if they should be recused and they're still giving input, whether they're doing it from the back of the room or however they're doing it, if somebody's going to be in a position to testify that that commission member was recused but was still trying to influence the other members of the commission, that's a problem. Another thing, if that commission member goes and sits in the back of the room and then says to either the opponents or the applicant, let's talk. That's a problem. That person should just stay the hell out of the discussion. That's as simple and direct as I can say it. Yes, sir.
The opponent can ask for a recusal, a commission member can ask for a recusal, or the applicant can ask for a recusal, can the CEO ask if anybody should recuse?
From a legal standpoint, the question is, can a CEO ask a commission member to be recused? Yes. Yes. If the CEO's not worried about his job. But yes. I mean, there's no reason why anybody who knows of a potential conflict of interest cannot raise that. Any person is entitled to do that. As I said, I mean, for a CEO, that might be a risky thing to do, but from a legal standpoint, okay, I'm going to move on. The legal objective of lending confidence to the municipal decision-making process is also served by freedom of information laws and by rules against ex parte contacts. In other words, contacts an agency member has outside of a public meeting with persons who may be interested in the outcome. And that's just what I was talking about before. Again, the objective here, think of the main objectives, public confidence in the process. Public confidence in the process. If you go to a commission meeting and commission member X is standing with the applicant or the applicant's consultants and having a great conversation, and then going up and sitting down and not saying anything while on the commission, you as a member of the public have a right to be suspicious. What were they talking about? What is it that this commission member now has heard that might become a basis for his or her decision? What does he or she know, or what did he or she hear that they're not telling us about? If you as a commission or as an audience member can't answer that, you're not going to have confidence in the process. And again, it works not just with applicants, but with opponents as well. When you've got commission members that are dealing with people outside of the context of the public meeting or the public hearing, that means the public doesn't know what's being said. And so those kinds of contacts, which are called ex parte, which just means one-on-one, but really from our standpoint means outside of a public meeting or hearing process, those can compromise you. Now those are tough for commission members, particularly commission members in some of our smaller towns. And this is the Northwest Hills COG. All of you are smaller towns for the most part, okay? So you know a lot of people in town. Maybe you know the majority of people in your town. And you're friendly with them. And there's nothing wrong with that. That's perfectly fine. You can be friendly with people in town. But what that means is people feel that they can come up to you and buttonhole you and talk to you about something that's pending before you. And because of this ex parte rule, and now you understand why there's an ex parte rule, because of this rule, it's dangerous. You're at Stop and Shop. Somebody comes up and buttonholes you and starts talking to you about a particular application. You're standing in the canned goods aisle. Somebody down in soups is looking over your way. They see you talking to that person. Then they go to the public hearing, and you don't say anything about having had a conversation in the canned goods aisle with person X. You get toward the end of the public hearing, that person stands up and says, I saw Commissioner X 3 weeks ago at Stop and Shop talking to so-and-so here, Mr. Applicant or opponent, about thus and such, and they haven't said a word about what they were talking about. They should recuse themselves. Now you're caught in a bind. The discussion that you may have been completely innocent, but somebody now has put you in a position where it could appear to be very dangerous. That's why it's so important and so difficult when that person comes up to buttonhole you to say, look, you know, I understand you want to talk to me about this, but you have to understand I really cannot do this. Please, 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 if you have any questions, come to the public hearing, come to the public meeting, whatever is going on, and ask your questions there, and I'll try to help you there. But you have to understand, if I talk to you outside of that, whatever decision I make could go up in smoke. I really can't talk to you. They often will not understand that. They often will not believe that, because they haven't attended a session like that. They've been smarter. They've stayed home and watched TV instead of coming to watch me. So they don't know that. And they may not believe it. They may find it hard to believe. But that's what you've got to do. You really have to be very careful. Now, if they buttonhole you and won't let go, or they call you and leave you an extended message on your voicemail or whatever, the safest thing for you to do, when you get to the meeting, the very next meeting, you say, I just want to let everybody know, so-and-so called and left me a message, and this was the message. And I'm just letting everybody know, I didn't call the person back or whatever, but I want everybody to know that this message was left for me. If they send you an email, only to you, here's the email, I'm submitting it for the record. If they buttonhole you at Stop and Shop, I just want to say, so-and-so buttonholed me at Stop and Shop, and you know, I told them that I couldn't talk to them about this application, and we didn't end up talking about the application, or the only thing I told them was come to the meeting or the hearing, and I just want everybody to know that happened. That's what you need to do. As ridiculous as that might sound, that's what you need to do. You cannot have the risk of having a court say you had an ex parte communication and it may or may not have been problematic. Some question.
Several years ago, a town resident I know asked me about something that was involved with executive session, and I refused to answer it. But since then, that issue has been resolved, and Ken Slater, it's okay. I mean, it's actually, you can look up judicial clinic and see what the result was. But if that fellow ever asks me again, can I tell him how the executive session and the litigation was resolved?
Okay. Very good question. All right, this is a Freedom of Information Act question. Freedom of Information Act, again, we started off at the very beginning, you have to operate under state law. Freedom of Information Act is state law, so you have to comply with all of the Freedom of Information Act provisions. One of them is, you can only hold executive sessions when state law says you can. And there are very, very limited circumstances where you can hold an executive session. Oddly enough, State law doesn't provide any penalty for any person who reveals information outside of an executive session. There is no state law prohibition on that. In fact, in some respects, the whole concept of the executive session is inimical to the goals of the Freedom of Information Act. They want to get as much information out as possible. So executive session reduces that a little bit. So the agencies aren't going to care whether you have the executive session or not. They're just saying you can if you want to under these circumstances. You don't have to. So there's no state law penalty for revealing something that was said in executive session. There may be something in your local charter or your local ordinances or maybe your local bylaws that will talk about that. In fact, I've just been reviewing a set of bylaws for one municipality where it specifically says that commission members who discuss things in executive session are prohibited from talking about them outside of the executive session. Again, the irony is there really is no penalty for that because they can't force you off the commission. State law doesn't allow them to force you off the commission for doing that because you're just violating some local rule. Your charter or your ordinances might have something about that. And if you're operating under state law, with state laws, particularly if you're in an appointed position rather than an elected position, if you're in an appointed position and you're appointed by, let's say, the selectmen or town council or city council, they may have ordinances that say in the event that somebody does that, they can be removed by the person that appointed them. So that's a possibility. But unless there's something like that, there really is no prohibition against you revealing information that you gained in executive session. But certainly to the extent that something happened in executive session and whatever it was you were talking about is now fully exposed to the public, I don't see why you should be precluded from doing that. Okay, yes, sir.
Regarding the ex parte communication, is there a limitation on who that person that you should stop that conversation with? I mean, I understand, the petitioner, the opponent, obviously, right, anyone else that you know is involved with it, but that could extend to anybody, right?
Anybody.
at all.
You're not even supposed to talk to other commission members. Even talking to another commission member outside of the hearing or the meeting is an ex parte communication. And part of the reason for that is the goal of freedom of information and the whole concept of this ability of the public to have faith in their government is compromised by information being exchanged outside of the public forum. So the goal of these rules and the goal of the Freedom of Information Act is when a decision is made, everybody has the right to know everything that you've based that decision on. Now, they can't necessarily know everything that's in your head, but theoretically, they're supposed to be able to know everything that was said to you, every piece of paper that it was given to you in order to help you make that decision. And so even commission members talking outside the public hearing is an ex parte communication. So nobody, you don't talk to anybody. Yes?
And sidewalks are listed as special meetings. Is that true? The commissioners may not speak to each other?
To
each other?
outside of a special meeting?
Going on a site.
Oh, on a site visit. Okay, site visit. Site visits can be set up in different ways. The question was, is the non-communication applicable to site visits? Site visits can be set up in different ways. If they're set up as a public meeting with minutes being taken and the public being able to attend those site visits, then you can talk to one another. If they're not part of an official meeting or public hearing of the commission, they're ex parte communication. Okay? So, and the site visits, as you can imagine, site visits are problematic because you have a lot of situations where you want to get onto somebody's property in order to make an inspection that you think, in order to gain the information that you think you need to make the decision, and they don't want you on your property. The applicant doesn't want you on the property. The applicant has to understand that if you really need the site inspection in order to make a proper decision, they have no choice but to either allow you on with the public at a designated time, under controlled circumstances, or you won't be able to make that site visit. And if you're not able to make that site visit and you truly needed the information that you would gain from a site visit, then you may have to deny the application. But site visits are problematic for that reason. I have seen situations where landowners have said, I'm going to allow the commission on, but I'm not going to allow the public. That doesn't work for the commission, because under the Freedom of Information Act, if you are getting together for the purpose of discussing official business, even if it's not an official meeting per se, that can be considered to be something that is a public meeting under the Freedom of Information Act, an unofficial public meeting, and that means that the public can be required to, must be allowed to attend. Interestingly, Freedom of Information is controlled by a different process. If there's a violation of the Freedom of Information Act, that's not going to get appealed to the courts right away. That's going to go to the Freedom of Information Commission. And so the Freedom of Information Commission may decide whether there was a violation of the FOIA in not allowing the public onto a piece of property. But the Freedom of Information Commission has the power to overturn a commission's decision. They have the same power that the court has to overturn a commission's decision. Now, the FOIC decision itself is subject to appeal, but they do have the state, there is a state law in the Freedom of Information Act that allows the FOIC to overturn a commission's decision for a violation of the Freedom of Information Act. Yes, sir. Let me go to the person in the back. You haven't had a chance yet.
As staff to a commission, let's say a public hearing goes multiple days,
Yeah.
am I held to that same ex parte communications about maybe if I'll be listening as well and recommending things to the commission?
You're at staff meetings you're talking about?
Well, yeah, so for instance, I'm at the public hearing, it's postponed to the next, continue to the next session, so we
Yep.
have 2 weeks.
Yep.
When someone comes to the counter and talk to me, or somebody that's said in public, am I allowed to still consult and do things? Even though
Okay.
I didn't give a recommendation?
Excellent question. Commissions are entitled to input from their staff. It's one of the few exceptions to certain rules that the courts have set up. For instance, if there's been a public hearing and the public hearing is closed, the rule is nobody is allowed to talk to the commission or to add anything to the record once the hearing is closed. However, the courts have made exception for commissions to get advice from their staff, from their attorney, from their consultants. The limitation is the input has to reflect discussions that have been held on the record. No new stuff can be added. So for instance, let's say there's been a discussion, it's a subdivision application, there's been a discussion of whether or not there's going to be traffic congestion on Street A, or traffic congestion at a proposed new intersection that the applicant has on their subdivision plans. And during the course of the hearing, the commission, there's sort of a consensus of the commission that we're not really happy with the information that we've been given about this, so we just want to tell you, we're not really sure we're comfortable with this. And then the hearing is closed. Staff can come to the commission later and say, no, I've looked at what's been submitted and here are my thoughts about that. Staff can't come in and say, I talked to the applicant about that, here's a new report that I've looked at to help me make my decision. No, because that's outside of the record. So staff is in a position to consult with the commission even during the non-public sessions of the commission. It still has to be on the record, but you don't have the ability to add to the public record. I would not recommend, this is me, and I tend to be a little bit ultra-conservative when it comes to risk management for commissions. I would not recommend, if you're a staff member, having lengthy discussions with commission member X about a pending application. Because again, what you're doing is putting those discussions outside of public knowledge. And so that means that that commission member now has a wealth of information possibly that nobody else has. And so if somebody finds out that a commission member has been having extensive discussions with staff off the record and doesn't disclose them during the public hearing, that could be a problem. I understand though that, I mean, that's the role of staff, to try to provide assistance to the commission. So my thought is perhaps the best way to do that is to try to channel the information through a particular commission member, normally the chair. And if the chair has those kinds of meetings, or any other member has those meetings, then when you get to the next public session, you reveal them on the record. I just want to say, you know, on Thursday, I had a lengthy discussion with, you know, you about, or whoever the staff member is, about a particular issue, because I was concerned about this, and this is what I came away with, something like that. Put it on the record, so at least nobody's going to say they were compromised by that ex parte communication. See how easy this stuff is? This is what I mean. We're just talking right now. We just started this. And look at it. I mean, this is what happens with land use law. This is the way it is. All of these things come up. Yes, ma'am.
What about receiving communications after the public hearing is closed? I know that it can't be presented during deliberations, but should I be keeping copies of that communication in the file?
Right. Okay, the question is, what happens after a hearing is closed and you get communications from a party? And you answered the question correctly. What you should be doing is putting them in a file, but I put them in a separate sub-file, if you will. This is stuff that came in after the public hearing. So I just want to let everybody know we got this stuff in. The commission is not entitled to use this in its deliberations. That's the safest way to handle it.
But are they allowed to look at it?
They shouldn't be.
Okay.
They shouldn't be looking at it.
Okay.
Again, you know.
No? Okay.
All right. The rules of openness and fairness also require that decisions be based only upon evidence submitted as part of the formal decision-making process. In the absence of a procedural error, a court will typically uphold an agency's decision if there is any evidence in the official record to support it. On the other hand, if the record does not contain evidence to support the decision, a court will not allow an agency to defend the decision by citing other evidence that was never placed in the official record. This has become really problematic in the area when you have experts coming in to talk to you about an application. And it's most critical where you're dealing with natural resources. So if you're an Inland Wetlands Commission or an Aquifer Protection Commission or just, you know, a zoning commission or planning commission dealing with environmental or engineering information, you've got to be very careful when you're dealing with engineering analyses. Courts are now considering more and more natural resource decisions to be very technical in nature. And they typically say, for instance, you know, unless you're an expert, you can't determine where a wetland boundary is, because wetland boundaries are defined by soil types, and you have to have certain criteria to identify what the soil types are. If you're talking about whether a septic system will function properly, you've got to be an engineer to know whether a septic system is going to function properly. If you're worried about traffic impacts, you've got to be a traffic engineer to know whether a particular situation is going to happen or is likely to happen in a particular area. So courts are starting to hold that for many of these types of decisions where experts are involved, the reason they're involved is because only they have the qualifications to give you the information you need about a particular technical or scientific conclusion. So, what that means is, if an expert comes in and testifies to you, there is going to be no impact on this inland wetland. Or an engineer comes in and testifies to you, this septic system is going to work like a charm. And you don't have any contrary evidence. The courts are not going to allow you to just disregard that information. They're going to want you to explain why you should be able to disregard it, and they're going to want it to be a cogent reason. Maybe some people on your commission have that expertise themselves. If they do, it should be revealed on the record. If you've got an engineer sitting on a panel and you're reviewing engineering evidence, the person who's the engineer should disclose, I'm an engineer. It might seem like self-aggrandizement, you know, at that time, but you've got to put that on the record. I'm an engineer. I just want that to be, everyone understand that so they can know that I'm reviewing this as an engineer. So that if you have another engineer who comes up from the audience, and whether for the opponent or the applicant, says this is going to be, hunky-dory, and you've got an engineer on the commission who has revealed that she or he is an engineer and says, well, I don't buy it because I don't see this, that, or the other thing. Then the courts will allow you, in those circumstances, to take a different position, to say you haven't convinced us, the majority of the commission. Commission member X has expressed a lot of reservations. We think, we're going to go with commission member X. The court will allow you to do that. But if you don't have a commission member X, then you're not really at liberty to just discount that evidence. Now, there's the exception to that. There was a really, really interesting case involving inland wetlands. And I think I've got it. It may even be cited in these materials. I can't remember whether it was this year or last year, from the appellate court, where the commission rendered a decision denying an application on the grounds that there were going to be certain wetlands impacts and that the applicant had failed to provide sufficient information to analyze the impacts. The appellate court said, part one, the commission did not have a sufficient basis to deny the application because of potential impacts on the inland wetland, because the only evidence they had from an expert said that there wasn't going to be an impact on the inland wetlands. Part two of the decision, the commission's regulation said in order for the commission to analyze the impact, the applicant has to provide X, Y, and Z. In the course of the public hearing, the commission's own consultant said, I don't feel that I got X, Y, and Z. Didn't say there was going to be an impact, but just said, I don't think I got X, Y, and Z. The court upheld the denial on that basis. So the court said there wasn't enough information to conclude that there was going to be an impact, but it was the applicant's responsibility to provide sufficient information to the commission, and the applicant didn't do that, so decision upheld. So be careful of that. Again, I'm talking about experts now, but this holds true of any kind of evidence in a public hearing. If you have, I'm going to give you a ridiculous example. If you have a situation where 20 people testify that somebody, was wearing a blue coat, and nobody testifies that somebody was wearing a red coat, you can't find that somebody was wearing a red coat. If 19 people testify that somebody was wearing a blue coat, and one person says, no, it was a red coat, you can find that somebody was wearing a red coat. If it's not expert evidence, you don't have to believe any particular person. You're entitled to weigh the credibility of the people who testify. And so, if you find one person credible and 19 people not credible, you can make a decision on that basis. The court's not going to hold you up to mathematical percentages. And that's why this whole business that sometimes happens at public hearings. How many people are in favor of this? How many people are opposed? That holds no weight. It should hold no weight with the commission, and it should hold no weight with the court. Because the question is, what evidence was presented? How did it meet or not meet the criteria that the commission set? And is the evidence in the record enough to give you a leg to stand on? Did somebody with proper basis, a proper factual basis, give you information that allows you to make that decision, regardless of what other people might have testified? Yes, ma'am.
What if you have dueling experts? You have one that says, hey, this is going to work, and then you have another one that says, no.
You can believe either one. You can believe either one. You have to assess their credibility. It's the same thing that happens in court. He said, she said.
Are we
No. No, because the third person is gonna have to either agree or disagree with somebody. So I mean, again, you're talking numbers, you're talking percentages. If it's 2 to 1, you could have a situation where applicant comes in and says X. Opponents come in and say Y. You hire a consultant. Consultant comes in and says, you know what, Y. Commission says, you know what, X. Court's gonna uphold that decision. You don't have to concur with your experts. You don't have to concur with your staff. The commission makes its own decision. There's just gotta be something in the record factually to support that decision. Yes, sir.
Do you have any recourse if you have reason to believe that the expert, to doubt the expert testimony? Can you delay and hire your own expert?
Well, the timetables the question is if you have some doubts about what an expert said, can you postpone things or delay things in order to get your own expert? You can't delay the state timetable. That's one of the problems. State law is pretty specific. You have to make decisions within a certain amount of time on certain types of applications. There are provisions that allow the applicant to extend the timetable, but they don't have to. It's up to the applicant to decide whether to extend the timetable. So, if you have questions about whether the information that you've gotten from an expert is satisfactory, you've got to decide whether you have sufficient time to hire your own consultant to review that. The best thing to do because of that timetable problem, the best thing to do is to, when you first get an application in, you should decide at that point, to the best of your ability, what kind of consultants are we going to need to work for us? We want an objective opinion from our consultants. What kind of consultants are we going to need? You shouldn't wait until the information is presented and then get your consultant in at the last minute, because you know what's going to happen. The consultant comes in at the last minute, drops the report on the table. State law doesn't allow you to extend the hearing any further. And the person who's on the other side of what that consultant is, they're going to cry out bloody foul. They're going to say, this is not fair. This was dropped on me. I've had no opportunity to respond to it, blah, 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 blah. And now you've got a problem. So you should make that decision up front. I will say, that can always be a problem anyway, because you always have the battling reports when you have a controversial situation. And there's always somebody who's going to want to drop the last report on the table. The best way to handle that is for, especially if you have bylaws that will do that, is to make some rule about when reports have to be submitted in order to be given full consideration by the commission. Now, you can't stop somebody from filing something on the last day of a public hearing. You can't do that. People are entitled to present whatever information they want. So you can't stop them from dropping something on your table. But you can make it clear, if the information is provided to us only on the last night of a public hearing, the commission may not give it full consideration. So you're telling people up front, you do this to us, you're taking your own chances. But again, my basic suggestion is don't wait. Try to figure out what consultants you're going to need and have them on board right from the get-go. And I would also suggest, because for most types of situations where a public hearing has to be held, you've got a couple of months to start the public hearing, use that time to get your consultants on board and get them reviewing whatever has been presented so far. There were some questions over here. Yes?
I was just going to ask about, is it appropriate to question the credibility or the background of the...
Say again that.
I'm asking, is it appropriate to question the credibility, background, or whatever of the expert?
Okay, the question is it appropriate to question the background or credibility of the expert? Yes, you have to be careful about how you do that. Again, because you're riding this fine line of trying not to appear biased. And courts understand that. And courts understand a number of things. One is, even though you're supposed to be objective when you come in, courts say that doesn't mean that commission members are expected to come in with empty heads. Of course, they're going to have some kind of preconceived notions based on whatever has happened to them up through the course of their lives. Of course, they're going to have some idea about the way things work. So, of course, there are going to be some hard questions sometimes. Somebody may have, a particular position about something, And they've held it for a long time, and you come in and challenge that, and they're gonna say, you know, no, I mean, we've been doing it, why is this wrong? We've been doing it this way, or this is what I always thought, blah, blah, blah. They can say those things. And the courts are gonna say, that's a fair question. And it's better for them to do that than to sit back, let the hearing get closed, and then after that say, well, that's not what I understood. I've always taken a different position, and now the applicant, the opponents can't respond to what you've just said. So it's better to put those questions up front. You have to be careful. You have to be careful that it doesn't come across as biased. You can't say, well, I think you're a knucklehead. You know, what engineering firm do you come from? You're a bunch of jerks. You know, don't say stuff like that. And again, I'm not being totally facetious here. That's kind of the level it has to be in order for a court typically to say you've gone too far. But if you say something like, you know, I've never heard of your engineering firm before, how much experience do you have with this kind of situation? That's a perfectly valid question, perfectly valid. What is your experience, Mr. or Ms. Engineer, with this particular situation? You're proposing this kind of a culvert. How often have you seen this kind of culvert in action? And have there ever been any problem? Absolutely, you can ask those kinds of questions. Yeah, just be careful of trying to make them, you know, don't make them sarcastic. You know, try to be careful how you do it. Try to be civil in how you do it. But yes, you can ask very, very tough questions. Yes, sir.
Particularly in cases where you've got ruling experts, is it valuable for the commission members to explain the reason for their vote for the record?
It's often very, very helpful for a commission member to explain why they've done what they did. Here's kind of a weird fact. When courts review agency decisions, they will say, if the agency has given reasons for its decision, those are the only reasons we're going to look at. We're not going to allow the commission to raise any other defenses. We're going to force them to stick with the reasons they've given. If the commission doesn't give any reasons for its decision, the court will say, well, we're going to examine the record and see whether there are any possible reasons why the commission did what it did. So it doesn't make any sense, literally. I mean, the courts are saying, we want the commission to be above board, we want people to understand why the commission is doing what it did. On the other hand, if they're silent about why they did what they did, we're going to review the record even more than if they're not silent about it. So it seems counterintuitive. But what I would suggest to you, just as a matter of public policy, courts still, despite that rule, courts still appreciate hearing from commission members what it was that they were concerned about. And sometimes in a very close case, that will tip the balance. If a court finds that a commission was very above board, giving its reasons, that court, generally speaking, is going to bend over backwards to find a way to uphold that. If the commission was silent, didn't give any reasons for what it did, the court understands that the rule is that they have to search the record, but the court might not be quite as thorough in searching that record as you might like. So I would say the answer is, although, despite this rule that the court will search the entire record for reasons if you don't give any, I think it's much better as a matter of policy and, you know, showing the court good faith that you do explain as much as possible why you're doing what you're doing. And what I would say is, the way that you get around that problem of the court's not going to search beyond the reasons that you give, it should teach you to be thorough when you announce your decision. Announce all of the reasons why you did what you did. Oftentimes what I've seen is, as the vote is going to be taken, the chair will say, okay, we're going to go around the table and ask each commission member to tell what he or she is thinking about this application. It's a good idea for each commission member to be as thorough as possible in explaining why his or her vote is going to be what it is. And then when you get to the end, then you can say, you can make the motion, and you can incorporate all of the reasons that go along with what that decision is going to be. So if you've got reasons for denial from 4 commission members and reasons for approval from 1, you know it's going to be a denial. So you can say, if the 4 commission members, this one had A, B, and C, this one had A, B, D, and E, this one had C, F, and G, you incorporate all of those reasons into the decision. So you need to have your secretary or your clerk carefully marking those down so you can do them. And one thing that a lot of commissions will do, they won't render the decision immediately after they have that. They'll go around and they'll do a consensus, they'll have their clerk marking down the reasons, and then they'll have staff or the attorney for the commission or whatever draft motions for the commissions to formally consider. And then those motions will be on paper at the next meeting, and they will contain all of the reasons that were in favor of that particular outcome. So that would be a practical way to do it. Yes, ma'am?
Is it still okay if, a lot of times what we've done is explain the reasons in the deliberation after the public hearing's been closed, and then there's the meeting of the commissioners before they make their decision. If in the body of the minutes and the recording states all of that, the reasons why the commissioners were going to vote the way they were going to vote, is that sufficient enough, or does it have to be in the motion?
Okay. The question is, if all of the discussion is captured in the minutes, does all of the reasons have to be in the actual vote, or is it sufficient to capture them in the minutes? On a very hyper-technical basis, it has to be in the vote. Because what the courts will say is, the views of one particular member of the commission are not going to be used by the court, or not going to be considered by the court as a reason that affected the whole commission. If only one commission member said A, none of the other commission members said A, and it wasn't adopted, the court is not going to look at A as an official reason. Okay? So you do have to vote. The court will only look at, generally speaking, I say the court generally will only look at the collective statement of reasons, not any one commission member's reasons. Sir?
What might that look like or sound like, that decision that you make to deny or approve something that has within it reasons?
Motion to deny the application. The commission finds that A, B, C, D, E, F.
So therefore.
Simple as that. Yep. Motion to approve the application. Motions to approve typically aren't as tough, because motions to approve, it's kind of implicit that you found that the applicant has met all of the criteria. So you don't necessarily have to say we find that the applicant's met all the criteria. That's implicit. A motion to deny is different because you don't know why the denial is going. You don't know what criteria weren't met. But with a motion to approve, it's typically, it's not as difficult. However, if there's been a lot of debate, a lot of contention with regard to a particular criteria, criteria regulation 105.4 says that the applicant has to prove thus and such. And there's a lot of debate about whether the applicant proved thus and such. It's still probably implicit if you approve the application, but it's often helpful to say, despite debate on this, the commission finds that the evidence favors, this finding, or you could say that the commission finds that the applicant has satisfied all of the criteria, including, but not limited to, the things that were matters of contention. Okay. I'm almost through 2 pages. Wow. I got such a big crowd here, I feel like I should be dancing or singing or something. But then you'd be sorry. All right. Although most agency decision-making will involve the routine application of statutes and regulations, certain types of uses bring special legislation into play. Such uses often operate on a different set of legal principles, so it is particularly important for agency members to understand them. The most common of these special uses include affordable housing applications, religious uses and uses that support religious practice, Uses involving persons with disabilities, telecommunications facilities, governmental uses, and most common of all, signs. And because those are all special topics, I'm going to leave those for now, but those are all special areas of concern. And then finally, the enforcement of land use regulations is obviously important to the success of those regulations. However, individual agency members generally have little to do with enforcement. Rather, enforcement proceedings more typically involve designated enforcement agents or less frequently actions by an agency as a whole. It is important for municipal land use officials to be clear about who has the proper authority to initiate or undertake enforcement proceedings, what limitations exist on such activities, what procedures are legally available in different situations, and what steps must be taken to proceed against any claimed violation of regulations. By sitting on a commission, you are not an enforcement agent. You do not have the right to go onto somebody's property because you are a member of a commission and that person has an application before you. You do not have that right. And I don't care if your regulations tell you you have that right. You do not have that right. This is Fourth Amendment stuff. People have a right to security in their property. That is a federal constitutional right. You can't take it away from them by regulation. They have the right to exclude you from your property. So, if you want to be an enforcement agent, number one, you have got to be given sufficient authority by your commission to be an enforcement agent, number one. And number two, you have got to secure appropriate authority either from the landowner or from a court to get onto property, if you want to get onto property. Same thing is true for actual official zoning enforcement agents. You're going to hear different things from attorneys about this. And I tell you, I'm very conservative, I'm risk averse, so I'm going to tell you what I think. I've seen, I don't know, countless application forms that say by signing this application form, you're giving the commission the authority to go onto your property. Baloney. Baloney. You're in control of that applicant's project. You have the right to regulate it. You have a right to decide whether to approve it or not. You do not have a right to hold a gun to the applicant's head and say, if you don't let me onto this property, I am not going to approve this application. You cannot do that. There was a court case recently called Kuntz versus some district. I think I have it cited in the materials. United States Supreme Court. And it was a situation where the court was dealing with an applicant who wanted a particular development project to go forward. The district said to the applicant, well, no, we don't think we're going to do it. However, if you dedicate this piece of land to us or give us a certain amount of money to buy other property that we can hold for a public purpose, then we'll approve your application. So they didn't actually take anything from the applicant. They said, but we're not going to approve your application unless you agree to this. The applicant went to court and claimed a taking of property under the Fifth Amendment. The Fifth Amendment says that a property cannot be taken from a citizen without due compensation. And that normally happens in traditional condemnation cases. The government comes in and says, we're going to take your land to build a bridge, and here's the money that we're paying you for that. So there's compensation, and then the fight is usually about whether the compensation is adequate. In some instances, like the little pink house down in New London, the question is about whether the agency actually had the authority to condemn in those circumstances in the first place. Inverse condemnation, though, the flip side of that is what happens with regulation. And that's where regulation is used as a means of taking property from people. They're called exactions. When you, under a regulation, you say, you have to give us this piece of land, or you have to give us a certain amount of money in order to get this permit. That's called an exaction. And so if a permit is granted based on an exaction, conditioned on an exaction, the U.S. Supreme Court has decided a number of cases that say this is the only way that that can be proved to be legitimate. And one of those things is the exaction has to be based on the harm that the development is going to cause. It's got to be related to the harm that the development is going to cause. And it has to be proportional to the amount of harm that that development is going to cause. So in this particular Kuntz case, what happened was the agency defended the case by saying, but we didn't take anything, we denied the application, so there was no taking. We didn't say, here's the permit, give us the exaction, we denied, so there's no taking. And the Supreme Court said, no. The landowner has a right not to be subjected to the threat of a taking in order to get a permit. And the court said, even if the government doesn't have an obligation to give the citizen a particular thing, if the government is gratuitously giving the citizen a particular thing, even then, the government cannot say, but we're not going to give you this particular thing unless you give us something else. So the government can give you something for free, but they can't say, getting this for free requires you to give us something. Now, that's a different set of facts, but I put that in the perspective of somebody who's going to a person's property and saying, if you don't let me on your property, you're not going to get your permit. I don't think that's much different. Now, it hasn't been tested in Connecticut, but in the case of inverse condemnation, where there's a violation of a person's federal constitutional rights, there is a statute that allows the person who did that, who was guilty of that taking, to be charged with a civil rights violation and have to pay monetary damages. And again, under Connecticut law, you're indemnified as a commission member, meaning the government, your municipal government has to pay your expenses if you were acting within the course of your duties. But a lot of the cases say if a commission member is doing something that's outside of the scope of their duties, they're not protected. Do you want to be the commission member that tests that? Do you want to be the commission member who says, I got this piece of paper where you said I could go onto your property, and so I'm going onto your property whether you want me to or not? Do you want to be the one who makes that? I would. You can if you want. I wouldn't recommend it. Yes, sir.
Is it permissible for a commissioner to accompany the enforcement officer on a piece of property? The enforcement officer is going to see how things are going and so forth.
The question is it okay for a commission member to accompany the enforcement officer onto a piece of property? The answer to that question is the commission member has no greater authority than the landowner has given that commission member. So even if you're the zoning enforcement officer, think of this. There was a Connecticut case involving a landowner who was accused of a zoning violation. Zoning enforcement officer wanted to go down and get into the property to check whether there was a zoning violation. Landowner said, no, not going to let you onto the property. Then the landowner built a fence so you couldn't see into the property. The zoning enforcement officer goes to court and says, court, I want you to issue me a temporary injunction to get onto the property so I can do an inspection, because I think there might be a zoning violation on there. Court says, okay, I'll give you a temporary injunction. The Supreme Court reversed that decision and said there has to be probable cause for an enforcement officer to go onto property to check whether or not there's a zoning violation. There has to be probable cause, which means that there has to be some legitimate basis in fact, not just speculation, for that zoning enforcement officer to go onto the property. And at this point, the zoning enforcement officer had nothing. All the zoning enforcement officer would have had was what the court considered to be speculation that there might be a problem. So what the Supreme Court says is the court can issue an order to allow you onto the property, but it has to be based on probable cause. And probable cause has to be something that convinces the court that there is some reasonable likelihood that a crime or a violation is occurring. So even in that case, even just in Connecticut, the court has been somewhat conservative in allowing the enforcement officer himself or herself to get onto the property. And a zoning enforcement officer has at least some arguable authority under Section 8-12 of the general statutes to do these inspections. Commission members don't have that. They don't have that. So going onto the property without the owner's authority is dangerous. I do not recommend that at any point. You've got to get real authority from the applicant, and it can't be gun to the head. You sign this paper, we're going onto your property. That's my position. Again, some lawyers disagree with that. Some lawyers think signing the paper is fine. I don't believe it, because to me it's like Kuntz. It's like you told the landowner you're not going to get this unless you give up a property right. Yes,
Would
sir.
aerial imagery constitute probable cause?
Aerial imagery can, in some instances, constitute probable cause. You would have to provide sufficient information to the court to determine that the aerial imagery is reliable, that it wasn't, that it came from a reliable source and was not tampered with, and that the aerial imagery shows something that clearly shouldn't be there, like a deck that's, too close to the property line or something like that. So yes, that can be used as a piece of evidence. It may not be foolproof, depending on the situation. I think I probably should take a 5-minute break. I'm not worried about me. I can keep on going. How many people want to take a 5-minute break? Holy crow, really? Just you two? What's the matter with you two wusses? Ladies, feel free to take a 5-minute break. We're on 5-minute break.